Hey there, this is Pat Ennis of Ennis Legacy Partners. Welcome to the Exit Readiness Podcast. I'm here with co-host Walter Dial, CPA and tax partner at GRF CPAs and Advisors here in Bethesda, Maryland. Our mission here on the podcast is to provide you, the business owner, with subject matter expertise on topics pertaining to building sellable or transferable business value, and then for planning your eventual exit from the business. We want to help you build a business that's transferable and then help you exit successfully and on your own terms and conditions. Non-competes and other restrictive agreements. You've heard us talk about them here at various times in the past. If you're a regular listener, they're essential when selling a business because they protect the value of the business. They safeguard proprietary information. They help in maintaining key relationships. They help in reducing the risk of competition. These agreements, they provide buyers with confidence in the stability of the business that they're going to be acquiring. The agreements support higher valuations, and of course, they can prevent legal disputes. And by having these protections in place, you can ensure a smoother, more secure, more stable transition of ownership. Transition that's either planned with a sale to a third party or insiders, or transition that's unexpected in events of death or permanent incapacity of an owner. So this morning, we're again going to review the importance of these agreements and protecting the value of the business. We do this regularly. This is one of our regular revisits because it's so important. And so our topic today is the current state of non-competes and other restrictive agreements. And we have back with us, our guest is employment attorney Marc Engel of Lerch Early Brewer here in Bethesda. And Marc's our go-to guy on this. He's the guy. Marc, he's a regular guest at this point. This morning, this is his fourth time with us. He's been with us more than anybody else. Marc, welcome back. Good to see you again.
Good to see you. Thanks very much for having me. Really appreciate it.
You're welcome.
Hey, Marc, I'll start us off. So, I think that the laws on non-competes and other restrictive agreements do kind of vary state to state, but recently the FTC kind of stepped in and said, no, you can't have these agreements. And then I believe a court kind of put a hold on that. But can you kind of update us on where the whole thing stands with that FTC action?
Sure. As many of your listeners will know, the FTC had proposed a non-compete, a very, very broad non-compete ban back in January of 2023. In April of 2024, it adopted its final rule banning. It was a wide sweeping ban. Had it gone into effect, it was scheduled to go into effect on September 4th. However, a federal court in Texas enjoined the law from going into effect and essentially said that the FTC lacked the authority, among other things, to go ahead and issue such a nationwide ban. So as we're talking today, the FTC rule has been enjoined, which is set aside for the time being. It remains to be seen what the FTC is going to do in terms of revisiting the ban, whether it's going to try to modify that or not. To date, I'm not aware that there's been any appeal taken from that decision, but we're all sort of waiting to see what's going to happen next.
So the rules regarding these agreements, I mean, states can do what they want, right? They don't have a problem from other courts when they impose rules on those.
Generally speaking, that's correct. I mean, they don't have the problem that the FTC had, or at least the federal district court in Texas thought that the FTC had about its statutory authority, its constitutional authority to issue that kind of ban. States generally operate on a different foundation, and as a result, there are currently, by last count, about 14 states plus Washington, D.C., which have passed laws banning non-compete agreements in various forms. California, as many of you know, but in addition, North Dakota, Oklahoma, Minnesota, and D.C. have total or near complete bans on non-compete agreements, and a number of other
Hey,
states.
Mark, this is important because we have listeners all over the place, all over the country, and that was going to be my next question. Actually, you just answered it, but I want you to answer it again. Uh, how prevalent? My question was going to be how prevalent are laws throughout the country that ban non-competes and other agreements to some degree?
Yeah, I think the short answer, Pat, it's a great question, is that they're becoming they're prevalent now from my perspective, and if you took a snapshot in time, they're certainly more prevalent than I think they've ever been, historically. And I think that's a trend we're probably going to see in certain states. There's certain states that have said, categorically, they're not going to go ahead and pass those types of non-competes. If, the New York governor, for example, vetoed legislation under pressure from Wall Street. The Rhode Island governor vetoed an outright ban because it would put the state's businesses at a disadvantage, and Maine also rejected the ban. So you do have some states that have kind of looked at this in a very different fashion, but I'd say by and large, there's a fair amount of energy across the country for some type of non-compete. And so what you see it breaking down is states and jurisdictions that have complete bans, okay, such as California for all practical purposes. And then you have bans to a lesser degree. So, for example, in Maryland and in Virginia, you have bans on what are called so-called low-wage earners. In other words, folks that are below certain thresholds that the legislature believes should not have that kind of ban in place. Okay, so we've got a little bit of a crazy quilt of laws throughout the country that exists. But then on top of all of that, right, just simply because there's not a law that prohibits non-competes, they still have to pass muster, from what's called a common law perspective, from a judge-made perspective. And that's really an analysis of the reasonableness of the scope of the non-compete.
Okay, so this what you just mentioned just now, and the crazy quilt comment you made. One of the things that if we're doing like a pre-sale due diligence with a client, just helping them be on top of everything they're going to need to be on top of for a successful transaction, we're going to bring this area up, and we always say if you haven't reviewed them in a while, if they have them, they may not have them, but if they do have them, we always say, you know what, you should. When was the last time you reviewed them? Can you speak to that? I mean, as to why it's a good idea to not just put these on the shelf and forget about them, but because of your crazy quilt comment and anything else you would say, why is it a good? And is there a good time? Every 1 year, every 2 year, every 3 years, whatever.
Yeah, no, it's a great question, Pat. I mean, I generally recommend looking at these things every year, every 18 months. And what clients find, believe it or not, is they have different versions sometimes of these so-called non-competes sort of floating around, right? They have one that's, working with a client, one that was 12 to 15 years old, I just recently found. And they no longer use it for new employees, but it's out there with a few of their employees, right? Some of the non-competes do not have what's called a choice of law provision, right? Which, in other words, what's the governing law that's going to apply? That can be an issue, and so it's probably more important now than ever to take a look at those non-competes to see, among other things, okay, do you have unanimity in the agreements that you're using, right? Right? Do you have them applicable with folks who may be so-called low-wage earners in jurisdictions that prohibit those? Some of these non-compete laws are prospective only, right? Most of them are, in my experience. But again, you're going to want to look at the dates that those were entered into. DC, for example, their non-compete law went into effect in 2022, and it was prospective. Okay. But nevertheless, when you're going to enforce those things, you're going to want to look at, well, what law applies? When was it entered into? Does it have what's called a choice of law provision? If the choice of law provision, let's say, is Maryland, and somebody for the last number of years has been working, the company's grown and they have offices in another state and no one's ever set foot in Maryland, well, that's the kind of thing that should be reviewed, right? Which law is going to apply, because that can matter significantly in the eyes of a court.
Okay, hey, Mark, something, and you don't have to answer this right now, but just so while I'm thinking about it, how does remote work? A lot of our clients, they have remote workers all over the country at this point, and how does this?
It's a great question, and to the frustration of a lot of us who do this kind of work regularly, a number of these non-compete laws really don't address that issue specifically. Okay, they're a little bit silent or ambiguous about the application of whether it applies to remote workers. Others not so much. I mean, I tend to take a conservative view of that. That if you've got somebody who's working remotely, and for example, in Maryland, even if someone's working remotely, I would want to be mindful of the state that they're working in, right, for the non-compete, and I'd also want to be looking at whether it's going to pass muster in Maryland, because I don't want to be put in that box where have that challenge of trying to say, well, it's lawful in one jurisdiction but not another. So you're looking in many respects for sort of common denominators. What's a non-compete or an agreement that's going to pass muster if you have many jurisdictions in a number of those jurisdictions, right? Another reason to look at these agreements is to look at who's receiving them. Do I have a one hat size fits all for all of my employees, which I see it was fairly common maybe 5-10 years ago in particular. Now increasingly I'm advising clients, look, let's customize this. Let's see the restrictive agreement that an executive, needs or should consider for an executive is not necessarily the same one that you would want to have for, a mid-level manager, so to speak. No disparagement of mid-level managers, but there's a different protectable interest. Are they client-facing? Okay, or are they back office folks that never interact with clients, so that it's going to seem unreasonable? Which kind of leads me to a different point, if I may, Pat, because kind of pivot and move to a related issue that you and I discussed, which is when people use the term non-competes, a lot of folks use it sort of interchangeably and generically. Okay, and so I think it's really important to kind of look at these as four separate things. The pure non-compete, you can't hang out your shingle, Pat, and do what you do, right? I can't, come and be next door to you and hang out my shingle. That's a pure non-compete. You have certain areas and certain substantive areas that prohibit those kinds of restrictions. Lawyers, for example, right? In Maryland, at least, those sorts of non-competes were not going to be ethically valid. Walter, I'm not sure exactly how that would play with accountants, probably less so, but there may be ethical constraints, that in terms of how broad they can be, right? So that's item one. Item two is a non-solicitation, right? And I look at those in two pieces. One, non-solicitation of employees, right? And generally the rule of thumb there is courts are going to be a little bit more willing to enforce those, all things being considered, if employee is reasonably defined. If it's anybody who ever worked for the company in the history of the company, right, 10 years ago, and they haven't worked for them, that's a non-starter. Okay. Then we move to non-solicitation of customers and clients, right? And that's where things get interesting. That's where a lot of the energy is and a lot of the litigation, in my experience. Many of these non-compete laws do not specifically address DC, for example. It doesn't specifically address the issue of whether it applies to non-solicitation of customers and clients as opposed to a pure non-compete, right? So a non-solicitation of a customer and a client, courts, in my experience, are going to look at more critically than the restriction, non-solicitation of employees, okay? Not as critically as a non-compete. That's the one that's really going to get the eyebrows raised, right? But they're going to look at in terms of non-solicitation of clients and customers. And again, these are broad stroke principles. How long is that restriction, right? How is a client or customer defined? If I work for IBM, right, or some huge company, it says I can't solicit any client ever that of IBM. That's going to be a real issue, right? And they're going to look at the individual's connection and relationship and nexus to those specific clients and customers. Do I have any idea that the company has been working with ABC business? Non-disclosure is the fourth piece, and that kind of falls into confidential information and trade secrets. And again, courts are going to look at those, probably be most receptive to those, okay, for a couple of reasons. If what is defined in a traditional confidentiality provision, where non-disclosure is reasonably tied to what the business does, right? Our financials, our marketing strategies, our customer lists, and so forth, and we take sufficient measures to protect those, the courts are going to usually say, we're going to go ahead and protect that, right? In addition to that, many states throughout the country have a version of the Uniform Trade Secrets Law, okay, which applies, right? And then on top of that still is the common law notion that you can't steal stuff, okay? I can't walk into Pat's office or Walter's office and start pulling things off the computers that don't belong to me, regardless of whether there's a statute that specifically says I can't do that. So those are going to be looked at. If you looked at them in terms of order of enforceability, again, broad generalizations based on my experience, courts are going to look at the pure non-compete super critically. And number one, they're going to do the analysis, does the statute ban it, right? If I work remotely, is the non-compete law broad enough to apply to remote workers? I look at that really carefully and really want to know how often the individual has connections to the state that's at issue, and also what's going on in that particular state in terms of a non-compete. If you pass that test, right, then the court's going to look at the reasonableness of the non-compete. Secondly, in terms of the critical view, they're going to look at the non-solicitation of customers and clients very carefully for the reasons I mentioned. Third, they'll be more receptive to non-solicitation of employees as long as they're well defined. Confidentiality, courts see that all the time, will generally honor that, and they really do not like people who take things that don't belong to them. So that's kind of a broad overview of it. But because of the new laws and because of the remote workers you mentioned, Pat, and also because of the fact that there's just, not wading into the political issue, there's a lot of energy nationwide on both sides, right, as to whether non-competes and restrictive agreements in general are good or bad. Do they help the economy? Do they help employees? Do they really help businesses and so forth? And so, and legislatively, in my experience, in certain states that are receptive to them, they tend to be a little bit of low-hanging fruit, in the sense that legislators can champion the rights of employees, particularly employees who aren't earning as much as others, to say, wait a second, do we really want to restrict the rights of people who are not making a whole lot of money and may need a second job to go get that second job?
Hey, Mark, let me ask you a question. So let's say a client, they meet with us and they don't have any covenants of any type, and they realize, that first they determine that it's legal to have them and that they need them. Isn't there some rule that for them to be effective, the employee has to receive something? In other words, you can't just say, oh, I don't have these agreements, let me go get everybody to sign them today. Don't you have to tie it into some money or something?
It's a great question. The legal term for that is what's called consideration. Do I have to give somebody something, right, in order for that, for the agreement to be valid and enforceable? If I say to you, if you say to me, well, if I say to you, Walter, yeah, I'm going to come over to your house and I'm going to paint your house this weekend, and you say, great, Mark, thanks a lot, I'll see you at 10, and I don't show up, right? And you try to enforce that agreement, Mark, why the heck didn't you come to my house? There would not be any consideration. In other words, no payment, right? Same deal in some states about whether consideration is needed and what that needs to be. In certain jurisdictions, continued employment can be sufficient consideration. In other words, you don't want to sign it, okay? You don't have a job. Other states and jurisdictions require some form of additional consideration. As to your point, Walter, sometimes that's money. So clients sometimes will look at revisiting and issuing restrictive agreements of one kind or another, and they may do it in connection with a raise or a promotion or a bonus, or a new, somebody who's moved laterally into a more, in a more favorable position. But yeah, it's a great question. Don't just assume that you can walk in, particularly if you're in certain states, and require everybody to sign it without checking what those laws are about what type of consideration, whether consideration is required, and what type of consideration is required.
Yeah. So, hey, Mark, for the benefit of our local listeners, which are, of course, serving people in Virginia, D.C., and Maryland, what could they expect in regard to that piece?
Yeah. So, continued employment is sufficient in Maryland. Maryland, in terms of what the localities have in terms of their non-competes, is kind of interesting. Maryland and Virginia, as I mentioned, have some form of what's called of a ban that prohibits non-competes on low wage earners. And in Maryland, it's 1.5 times. It's a formula. And effective January 1, the threshold became 46,800. Okay. The threshold in Virginia is somewhat higher, and it's tied to cost of living, I believe. And it's about, at this point, about 58,500, but that's subject to increasing based on, I believe, it's updated quarterly based on Bureau of Labor statistics. So again, the idea here is the legislature's made a conscious decision to say, folks, we're not going to go ahead and saddle them with a non-compete and essentially prohibit them from getting a second job should that become necessary, or they're not earning enough to justify essentially blocking them from working. In D.C., again, that's a more stringent ban, and it took effect in October of 2022. It bans non-competes unless someone is deemed to be highly compensated, which is a figure of $150,000 and $250,000 for so-called medical specialists. What's interesting about what's going on in Maryland, for example, in July of 2025, Maryland's new statute, its new non-compete, is going to ban non-competes for the folks in the healthcare space who earn less than $350,000 completely. Okay. And for folks who earn over $350,000 beginning July 1, those non-competes are going to have to be limited to a year and 10 miles in radius from the primary place of employment. And what's also kind of interesting about the new bill in Maryland is that the legislature did something that I really haven't seen very often. They by statute, they directed the governor to engage a consultant to look at the impact of private equity on healthcare. Okay, and so I think there'll be more to be said about that issue and the impact, and whether non-competes and the ability to use them with healthcare professionals is going to get further winnowed away over the course of time. But all of which, I think, if you look at the through lines that we were just describing, you see what I was just describing. They're becoming more prevalent, just in general. They're becoming more prevalent in the sense that folks are looking at industry-specific non-competes, right? Because the issue is, are non-competes hurting the public good? Is there a public element? In other words, if patients and folks in rural counties, for example, can't get medical care because a doctor has a non-compete, that becomes a concern for legislators.
Okay. All right. Fantastic. Okay. So as we wrap up here, are there some best practices for employers? And again, let's think national, not just here locally with the local folks, but some best practices for employers as they evaluate these agreements, non-competes, and other type of restricted agreements that you can pass along?
Yeah, absolutely. I mean, I think I'm going to be maybe a little bit of a contrarian with some of my thoughts on these things, but I think it's really important with these non-competes and other types of agreements, just as you mentioned, to really take a fresh look at these. It's a great time to dust them off. Number one, take an inventory, figure out what you have out there. All right. Many clients are going to be surprised by the fact that they have multiple versions. Number one. Number two, you're going to want to centralize the decision making when it comes to who's going to receive these, right, types of agreements, and when, and what kind of consideration, if any, we need to provide, right? So we're going to have the C-suite team or whoever it may be, right? You'll look at this so we don't have the one-offs with certain managers and folks, deciding they want to issue them for new hires, and all of a sudden folks at the highest level of senior management have no idea about that, right? So we want to centralize those decisions. We want to centralize the decisions about when to enforce them, okay? And I think it's really important to go through a checklist of things before you go to enforce those, right? Number one, how are they going to be met by the employee, right? Is the employee would they be likely to be litigious? Is there an argument that the employee may be owed money, so you're walking into a situation where there's going to be a counterclaim? Does the employee have an argument that somehow the employer has breached its obligations to the employee, such that the non-compete, if you will, is no longer valid or enforceable? Has the employer been consistent in how they enforce these things? All right. And then I always like to challenge clients. What is it that you're really truly trying to accomplish if you go to enforce them? What is it that what purpose are you serving that you want to validate? A lot of times, there's a very emotional piece to enforcing non-competes. Somebody's leaving, and doggone it, they're leaving the family, and it becomes very personal as opposed to a clinical issue about a vendor who's the copy machine's not working. Okay, and I got to find a new vendor. Okay, so it gets tied up in a lot of different issues. So it's really important to step back and take a wide angle lens and look at how these things are going to potentially play out. Number one. Number two, think about other ways of furthering the objectives of non-competes, okay, and restrictive agreements in general, right? If part of this is to preserve the goodwill of the company, right, my question and challenge for my clients anyway is to say, well, are there other ways to do that, right? Clients in general, in my experience, hate to get dragged into these fights between employers and employees over non-competes. Okay, it can really turn clients off, and it can be the sense of, I get a subpoena to find out whether John or Mary was trying to hustle me before they left. Guess what? A pox on everybody's house. I'm going to go find somebody else. I don't want to get dragged into that. And by the way, I'm not getting paid for it, and my employers are going to lose time having to testify about that. So, what goals am I really trying to further? Can I accomplish them in a different way? If it's confidential information and protecting trade secrets, can I password protect that information? Can I do a better job with my IT folks to make sure stuff doesn't get sold? Okay. Can I have interim steps? In other words, when people walk out the door, I have clients. I recommend the clients sometimes send a reminder, a departing letter reminder. You're leaving. This is to confirm you're leaving the company. We wish you well in your future endeavors, but we want to remind you that you have this agreement in place, and for reasons we trust you can appreciate, we take these seriously. And P.S., if you haven't done so, right, you need to return everything that belongs to the company, and you need to do so immediately. Okay, and then send them another copy of their agreement. That has a way, in my experience, of sort of sobering folks if they thought, oh, I don't remember whether I signed it. I get that a lot. I think I might have signed it. I think I might have received one. I don't know which version I got. I didn't want to sign it. I was forced to sign it. Well, now you have it, and here's what the expectations are going forward. So sometimes it can be diffused in that way. You're going to want to look at the circumstances as to when you're trying to enforce it. If there's a layoff, right, or there's somebody's been terminated without any wrongdoing whatsoever, do we really want to say we're going to go ahead and enforce that non-compete, right? Because judges may look at you like you have three heads. Another idea is a best practice, I think, is to, um, when you're undertaking this analysis of restrictive agreements, be mindful that they can be found in different places. You can see a non-compete or a non-solicitation in a standalone document that says non-competition agreement, right? But you can also see them in a buy-sell agreement. You can see them in stock option agreements, right? Sometimes I've even seen them in handbooks, okay, or one-off letters. So you want to harmonize and make sure that whatever it is you're trying to enforce, if it's a new agreement, harmonizes with what exists in existing agreements, right? Um, be careful about borrowing uh, agreements on the theory that I'm going to pull something off the internet, and if it worked for my friend who's in a different industry, it's going to necessarily work for me. I can't tell you how many times I've seen that, and you see these agreements and they make references to industries that have nothing to do with the particular client. Okay, so again, borrowing those, a lot of times you sort of get what you pay for. Um, the other thing is to keep in mind kind of what goes around comes around, right? Um, if we're trying to enforce an agreement that has a provision in it, at the same time, we're getting ready to hire someone who's got a very similar agreement, and we need to have a workaround to get that person hired. What are the optics of that, right? So again, there can be issues with that. And I think a final piece of this is to look at, whether there's always, I always encourage my clients, Pat and Walter have heard me talk about this for a while, about exploring and revisiting employment practices liability insurance. Okay, EPLI, which is a special kind of insurance for employment claims. Would it cover violations or alleged violations if employers get sued for this? Do we have coverage as an employer if I go to enforce one of these and I have a counterclaim coming back the other direction? Again, all things to keep in mind. As a general rule of thumb, as I mentioned before, a lot of these cases will depend upon what brought us to the decision to enforce the non-compete. If somebody is stealing things, okay, they have taken their hard drive, forwarded it to themselves. It's blatant. Judges have no patience for that, in my experience. And many of those cases are won and decided on injunction proceedings. Somebody goes in to get an injunction, and although the rest of the case continues, if the court grants it and is sufficiently persuaded, usually it's game, set, match. Okay, so I think they still have their benefit. They can have their benefit, but I think it's really important to sort of tailor those restrictive agreements if you're going to use them, right, in a way that makes sense for your industry. If you're considering them, make sure you're reviewing them with your attorneys so that when you're having these discussions, the conversation is hopefully going to be kept privileged and not discoverable.
Thanks, Marc. This has been great. I'm sure our listeners got a lot out of it. I know Pat and I did. So, just as we wrap up, can you let us know how listeners can get in contact with you if they want to?
Sure. The name of the firm is Lerch Early Brewer, and we're in Bethesda, Maryland. My direct dial is 301-657-0184, and my email address is Mr. Engel, that's Engel, at Lerch, and that's Lerch, early, like early in the morning.com. So for your listeners, we write a fair amount. I write a fair amount on employment topics. If I could pivot just for a second, there's a lot of energy nationwide with these pay transparency laws. Maryland has one that's going to take effect in about October 1st. DC has one that took effect this summer, and they have joined the list of jurisdictions, many jurisdictions throughout the country which have similar laws. So there are articles about the pay transparency, an FAQ that I prepared for DC, and for another one for Maryland, which are available on our website and also available if you'd like to reach out to me personally.
Fantastic. Thank you very much. Appreciate it.
My pleasure.
And listeners, if you want help in maximizing the value of your business or planning for your eventual exit, You can reach Pat at 301-859-0860, and you can reach me at 301-951-9090. You can also access resources at grfcpa.com and exitreadiness.com. As always, thanks for listening. And if you've benefited from today's episode, please consider liking and sharing it on social media. Until next time on the Exit Readiness Podcast, this is Walter Dial and Pat Ennis signing off.